Good afternoon, everybody, and thank you for joining this wonderful telecast. My thanks always goes out to the Apartment Owners Association for putting these live streams on. What a valuable wealth of information, and I really encourage anybody listening to this that the cost of joining the Apartment Owners Association is so nominal that really it's a wonderful business opportunity for you. As Jeff mentioned, my firm has been in existence for over 40 years, actually 45 years. I know you guys are probably thinking to yourself, how do I look so young? But all you have to do is get up very early in the morning. I'm usually up at 3:30 and then working out and then to the office. So that's the secret. That's the health secret for the day. I'm going to be talking today about the governmental assault on income property owners. Dan Fowler kind of alleged the issues of the government taking our buildings, and that's exactly what they are. I'm going to try to work through what these statutes are all about and what things we can do right now to protect our investments, and what type of eviction, since that's what I do for a living, we can bring at this time. And there are a lot of evictions going forward. My firm, just this week, I was adding it up before I came over here, we have 50 sheriff lockouts just for this week alone. So the courts are open. We are prosecuting cases. We are getting judgments, and we are enforcing those judgments by having a sheriff actually perform a lockout. We have 50 going on this week alone. So don't come in with the idea that, during the pandemic, I can't evict tenants. No, you really can evict tenants. Bad tenants, good tenants, people who are violating their rental agreements. We can go forward with that, and I will be discussing that. Let's first talk about today that a misnomer that we can't raise rents during the pandemic. That is not true. We can raise rents, and you should raise rents. All rents should be at market level. That's the way all people who own income property should make sure that their rents are in accordance with the other comparable units in that particular area. If you have a local rent control ordinance which is limiting or prohibiting rent increases, then obviously your building is subject to that local ordinance. But if, for example, your property is not under any rent control, let's pretend you have a single-family home or a townhouse or a condominium or property that was built within the last 15 years, those buildings are not under rent control, and you can raise the rent to any level. Obviously, the market is going to tell you what you can and can't get for a specific unit, but you certainly have the right to raise rent to any existing tenancy where the tenancy is based on a month-to-month agreement at this point in time. So, if you do have a single-family home or a newer place built within the last 15 years or a townhouse, I encourage you to serve a rent increase notice even on tenants who aren't paying the rent, because at least you're establishing what that rent should be, and when eventually the doomsday comes where the tenants are going to be forced to pay the rent, at least they're going to be paying at a higher level. If you are going to raise the rent, be aware that if you're going to raise the rent 10% or less, all you need to do is serve a 30-day notice of rent increase. If you are going to be raising rents in excess of 30 days, excess of 10%, then you're going to need to serve a 90-day notice of rent increase. So right now, ladies and gentlemen, there is no such thing as a 60-day rent increase notice. It's either a 30-day rent increase notice for all rent increases 10% or less, or if you're going to be raising it more than 10%, that would be a 90-day notice. Now, If your property is subject to statewide rent control, in other words, you're not subject to a local jurisdiction, but you do have multiple units, and they were all built more than 15 years ago, you can still raise the rent right now, today. If you are going to raise the rent right now, the rent increase is 5.7%. That's computed based on the 5% yearly increase plus the current CPI, Consumer Price Index. Now, that's calculated in April of each year for the LA and Orange County and San Bernardino areas for Southern California. Currently, that CPI for April of 2020 was 0.7%. So right now, you could raise the rent 5.7%. However, if you wait, then we get to wait until August 1st. Then we get to use the rate that was established as of April of the year 2021. That rate right now for those areas, and it differs between which counties you're in, but for those areas that I just quoted, it's 3.6%, which means as of August 1st, you can raise rents to tenants that are subject to statewide rent control a total of 8.6%. That would be a 30-day notice. You should actually serve that notice exactly on August 1st of the year 2021. You can raise those rents by 8.6%, which is a healthy rent increase. Again, you'd have to check for different counties. I was just quoting for Orange County, LA County, Los Angeles County, and also San Bernardino. But check your specific county as to what the CPI, the Consumer Price Index, was as of April of the year 2021. And then on August 1st, 2021, please raise your rent to market value. It's almost mandatory, ladies and gentlemen, especially on the basis of what our wonderful elected officials are trying to do. Now, before we go on to the eviction moratorium, let's still stick with our statewide rent control. Statewide rent control does require good cause to evict, so we just can't issue a 30 or a 60-day notice to a tenant to ask him to vacate. But there really is a way around the statewide rent control for almost any person owning property that is subject to that statute. And the way around statewide rent control, which is very simple to get around, is just to declare to the world that you're going to be renovating the unit. So, for example, if you had an apartment where you were just really lackadaisical on raising rent, you weren't acting as a proper business person, so you never really raised the rent, and now, of course, you find yourself stuck with statewide rent control. Now, maybe 8.6% come August 1st would make you very happy, and that would be a reasonable rent increase. But if your rent really was very low, and 8.6% truly would not be market value, you might want to consider renovating the unit. Obviously, a unit which has very, very low rent, probably in order to get maximum rent, you're going to have to do renovation anyway. So the requirements to evict a tenant under statewide rent control, and again, we're not talking local jurisdictions where probably you wouldn't be able to do this, but under statewide rent control, if your building is subject to that statute, you can do this renovation eviction. The requirements are that the work must take at least 30 days to complete, and you must be doing substantial renovation, which would require the obtaining of a building permit, like, for example, an electrical permit or a plumbing permit. So basically, you're going to be renovating the kitchen, or you're going to be renovating the bathroom, or both. And in all likelihood, if you really had very low rent on the unit, you'd probably be doing this renovation anyway. So anybody there who is basically way below market value, and their property is now subject to statewide rent control, which quite frankly, all you're going to be able to get is 8.6%. If that's not sufficient, then I would consider doing a notice to terminate the tenancy. Normally it would be a 60-day notice where you have to list the specific reason. So this notice does have to be set up specifically, which of course my firm can help you with. But again, the big thing is that you are going to do the work after the tenant vacates. It is going to take longer than 30 days to complete. You are going to obtain a building permit, like an electrical or a plumbing permit, and you will do the work. So now the unit is going to look really nice, and you'll be able to get maximum rent for that. So again, that is the escape valve for anyone who is stuck under statewide rent control, where the rent increases are not making them feel very warm and fuzzy. So keep that in your back pocket if you do know someone or yourself which is under statewide rent control and the rents are very low. Okay, so that's my discussion with regard to statewide rent control, what rent increases you can do now for property that is not subject to any rent control or property that is subject to statewide rent control. By the way, while I'm on the topic, you guys right now need to comply with statewide rent control rules. There are some forms that need to be served on your tenant right now. So if your property is not subject to any rent control, for example, a single family home, you have an existing tenant there, you want to serve him a notice that his property is exempt from statewide rent control. These are forms that you can get at no charge from this wonderful association, the Apartment Owners Association. And you want to make sure that you send that notice to your tenant. Why do you need to do that? Well, if you don't tell your tenant, your existing tenant, that the property is not subject to any rent control, then you can't raise the rent to any level and you can't serve a notice to terminate the tenancy. So please, if your property is not subject to any rent control for existing tenants, please serve them that form. Again, get it from the association. Do it today, not tomorrow, so that you're in compliance with the law. Now, if you're going to be renting out a unit that is not subject to any rent control, that phrase that it's not subject to rent control must be contained in your rental agreement, or at least as an addendum to the rental agreement. So again, make sure that you're using the AOA forms to inform anybody who's coming into your property who's going to be renting this single family home, or maybe an apartment that was just built within the last 5 years, so it's not subject to any rent control. Make sure that phrase is contained in the rental agreement. If it's not, then again, you're going to be limited to rent increases. You're going to be limited to terminating the tenancy. Okay? And by the way, while we're on the subject, if you are renting out a property that is subject to statewide rent control, you want to make sure that you do not use a 1-year lease. Forget that. Throw that away. You can make it an 11-month lease or a 9-month lease or a 6-month lease or month to month, but do not rent out property that is subject to statewide rent control on a 1-year basis. And the issue is, why would I tell you that? Because obviously it's very normal to rent out property for 1 year. But under statewide rent control, you do not need to have a reason to evict if, in fact, you're in the first year of the tenancy. So if you had a 6-month tenancy, at the end of the 6 months, for example, you'd be able to tell the tenant, I'm not renewing, you have to leave. You don't have to have a reason. Now, I don't know why it is, but when these guys and gals come to our apartment and we're going through the application process, they seem so incredibly nice. I mean, they are complimenting everything. They love the place. They're complimenting you. But then magically, as soon as the ink is signed on that agreement, all of a sudden you got yourself Attila the Hun. They're complaining about everything. They're just malcontents. That, I don't know, there's a crack in a wall switch, that they saw an ant in their kitchen. You know, maybe it was their uncle in the kitchen. I don't know. But whatever the story is, you want to make sure that you have a way out with these tenants. Again, I'm only talking about property that is subject to statewide rent control. So within the first year, you do not need a reason to evict. So rent it out as a month-to-month tenancy or rent it out as a 6-month lease. Do not do it as a year lease, because after the year, now you need good cause. So lots of times these tenants truly become malcontents. They seem so nice in the beginning. So when you are renting out property, again, subject to statewide rent control, please don't make that mistake by renting it out on a 1-year lease. So now you're locked in with the tenant. Now, if your property is currently subject to statewide rent control, you have to send them another form right now today that it is subject to statewide rent control. And again, if your property is subject to statewide rent control and you are now leasing it out, that phrase that your property is subject to statewide rent control must be contained in your rental agreement. This is under the state law, AB 1482, Assembly Bill 1482, and that's got to be contained within the rental agreement. So again, these forms are on the AOA website for all of their wonderful members. Again, I encourage people to join the Apartment Owners Association, and it's really a treasure trove of wealth and information in free forms. Okay, so that basically concludes the discussion on statewide rent control. So let's turn our attention to the governmental assault on income property owners. It's also called, at least that's what the politicians called it, they called it the Tenant Relief Act. It's not a Tenant Relief Act. What it is, it's a governmental assault on income property owners designed for the redistribution of wealth. In other words, we get up early, we work hard, and what the government wants us to do is to take our hard-earned labor, our hard-earned money, and donate it to other people. That's under AB 3088. I'm going to go into what this statute is all about, maybe ways to get around it. But I think I'm going to start with the ending first. And the ending first is that this statute is supposed to end June 30th. And that's coming up in what? In just a few days, like in about a week. And Dan Fowler was saying how he believes that it will be continued. And I'm hoping not. So I'm going to go on the position that it's going to be over as of June 30th, and what that means for landlords out there. If you think about it, if they do extend it again, it's really going to be a major ticking time bomb for tenants. Because the way this statute is written, and which I'll go into more fully, you still have to pay 25% of the rent from rent owed from September 1st, 2020, through now June 30th of 2021. So that's a total of 10 months, which means that on June 30th, they're going to need to pay 25% of the rent at least. Those claiming, falsely or not, that they were affected by COVID. But if they extend this again, then that 10 months is now going to be, what, another 6 months worth of rent? So now we're looking at 16 months. So for the politicians listening to me out there, if you really, a tenant's not going to pay the rent if they don't have to pay the rent. That's just what it is. If you leave the bank door open, people are going to wander in and just take samples. So politicians out there, think about this. If you allow this relief to continue, this governmental assault on income property owners, you are guaranteeing that you're going to have more evictions than you can believe, because the tenants aren't going to pay after July 1st if they don't have to. And if this extends for another 6 months after June 30th, how are the tenants going to be able to pay 25% of the 16 months? It's not like these people are saving the money. Do you know, as I take a breath here, do you know that I have at least 5 to 6 landlords calling me on a weekly basis where they say the tenants who have not paid them rent in all these months have just purchased a new car. I get about 5 or 6 people telling me per week, well, of course they're purchasing a new car. Do you know why? Because they have a bunch of money. Because they certainly are going to work. They're certainly gaming the system. I would say in 85% of the cases, these people are not affected by the pandemic, or at least they're not affected now by the pandemic. They're back to work if they choose to be back to work. And now, of course, they're going out and purchasing nice new cars. And at whose expense? At the expense, of course, the landlord. So for the politicians out there who are thinking that they're going to extend this again, I caution you that whenever this is over, the tenants are not going to have the 25% for the period of September 2020 through the end of this moratorium, whenever it will. And that's when you'll see the tidal wave of evictions. But if you at least end it now, Governor Newsom, if you at least end it now, then at least tenants will at least start to pay their July's rent and the August rent that they can afford. So please, Governor Newsom, don't do things just because you're going to get voted out of office based on the recall. Do what's right. Do what's right for tenants and do what's right for income property owners who have now suffered how long? What month is it now? It's really 17 months. 17 months that landlords have been able to exercise, the tenants have exercised their rights of not paying rent. 17 months. Which other industry would you have to give your goods and services to where the person who's buying it will say, gee, I'll see you in 17 months? And now our friendly politicians are trying to extend this. That's tantamount to insanity. And it will be insane with the tidal wave of evictions that will come. End this thing now. So let's talk about the governmental assault on income property owners, also known as AB 38, the Tenant Relief Act. What is this all about? How is it that tenants are withholding rent? And it's very basic. It's been approved by our state legislator and our wonderful governor. So what is this all about? Well, there are 2 periods of time that we have to be aware of. One is called the protected time period. The other is called the transition time period. Under the protected time period, we're talking about rent owed from March 1st, 2020 through August 31st, 2020. So for that period of time, that's considered the protected time period. If you have a tenant who owes money during that time period, then you need to serve a 15-day notice just for that time period. It has to go with an information sheet regarding the protected time period. It has to go with a copy of AB 3088, the law. And you also have to include a declaration that the tenant can merely sign and send back dealing with financial hardship due to the pandemic. So you basically got 4 forms that need to go when you're serving a simple notice to pay rent or quit. And again, that is not a 3-day notice, it's a 15-day notice. And when I say 15 days, I'm not talking calendar days, ladies and gentlemen. I'm talking 15 business days. So you exclude Saturdays, Sundays, and legal holidays. So we got to give the tenants 15 days to do something, but it's not 15 days. It's more like around 21, 22 days. So if you serve this for the protected time period, once again from March through August of 2020, what does the tenant have to do within the 15-day period? Very simple. All he's got to do is pay all the rent that he owes you. Come there and pay you in full. Or he can do something else. So what's the something else? All he has to do is sign this declaration that you provided, which states under the penalty of perjury that he's affected by COVID and he can't pay you the rent. Can you go behind that declaration? Can you ask for proof? And the answer is, of course not. Whatever he says, You have to accept there's no way for you to change that. So if you get that declaration, then the tenant's obligation to pay rent is zero rent. In fact, he never has to pay rent again. He has no obligation of any kind to pay rent. And that's because the politicians declared that if you get that declaration, that the tenant doesn't owe you rent anymore. They've changed the name from rent to something called a civil debt. A civil debt. Well, why did the politicians change the name from rent to civil debt? Because whenever this moratorium is over, and we're praying that it's in 1 week, June 30th, at that point in time, it's going to be considered rent. And therefore, I could serve a 3-day notice, the moratorium's over, to pay rent or quit, and proceed forward with a standard eviction. But you see, an eviction is based on, in a lot of cases, based on rent. But you see, this is no longer rent because they've changed the name. They changed it to a civil debt. So what can you do then? Well, under the current state of AB 3088 and as amended by Senate Bill number 91, it extended it until June 30th. A civil debt, all you can do is bring forth a lawsuit. It's due on July 1st currently, and you can bring forth a lawsuit as of August 1st, 2021. You can either bring a regular civil lawsuit or you can file in small claims court where the jurisdictional limit, which used to be $10,000, but for this type of a civil debt, it's unlimited. So for all the clients who call me and say, this guy owes me $15,000, this guy owes me $18,000, the losses are staggering, but you can go to small claims court and you can file a lawsuit against your tenant for that. I have one client that I just was interviewing with, and they're my new clients, somewhat famous people. And they showed me their portfolio of unpaid rent during this pandemic. And literally, I saw the spreadsheet journal on it, and the total on it from all their tenants was $2.1 million. $2.1 million. And I'm really tired of people saying, gee, I'm just a small property owner. I'm a mom and pop owner versus those corporations that have 1,000 units. It doesn't matter that you have 1,000 units. That just means you're successful. There's nothing wrong in our country with being successful. And I take pride of people who are successful. And the law should be applied equally, whether you're a mom and pop owner or whether you have 1,000 units, okay? Everybody is entitled in this country to earn a living, and everybody is entitled to have as much success as they possibly can. I mean, that's basically what our country is founded on. So the reality is that on August 1st, for any tenant that owes rent during this protected time period, again, from March 2020 through August 2020, you can go to small claims court. See, the politicians were somewhat insidious in the way they wrote this because they said, look, we're not forcing landlords to give up rent. We're not. We're telling landlords that merely the rent is deferred. You're going to get your money. Really? You really think landlords are going to get their money? I would be surprised if 15% of landlords are actually successful in collecting on this civil debt. Maybe 15%. Because, you know, if you go to court on August 1st and file your small claims court lawsuit, you're going to be assigned a case number, and you're also going to get a trial date. But the next thing you need to do is you need to serve your tenant with that lawsuit. Well, what about all the tenants who vacated, who left? No. And you'll see a bunch of them exiting come the end of this moratorium, again around July, because they know that you're going to now be filing a civil lawsuit and you're going to need to serve them. Well, where are they? Did they move to Idaho? Okay. Did they move to Oakland, California? Where did they all move to? Because you're going to need to find them. And even if the tenant is still in your unit, you can't evict for that rent owed, because remember, they changed the name. It's not rent, it's a civil debt. So in that situation, even if you knew where your tenant was to serve them, all that means is you're going to get a judgment against your tenant. Does the tenant have to pay it? Well, if he follows what civilly he's required to do, yes, of course he'd have to pay it with that judgment. But what if he doesn't? Do you know the basis of how to collect? Do you know how to find assets like where he works or where he banks? Are you going to be able to prepare the proper paperwork, which is a writ of execution for money? Are you going to know how to go through those steps to do that? Probably not, which means you're going to have to give it to a collection agency. I'm a collection agency. We collect a lot of debt for our clients, so we charge 50%, as most of our clients, most other collection agencies do, which means you're giving up half the money right then and there. So the chances of, number one, obtaining a judgment, and then, they don't have a debtor's prison in this country. So if you can't find assets, then that just means the debt's unpaid, which means it's a loss. And that's why I'm saying I think landlords will be lucky to get 15% of this lost rent, 15%. So that's dealing with the protected time period. Let's move over to the transition time period. The transition time period is from September 1 through currently the end of June. That's called the transition time period. If a tenant owes rent during that period, you want to immediately serve a 15-day notice, which just includes for that time period only. Again, you have to submit that declaration with your 15-day notice. You have to give them the information sheet, which explains about the transition time period versus the protected time period. And you also have to give them a copy of the law. So what is the transition? How does that differ? Well, for the transition time period, as I alluded to at the beginning of this topic, you have to pay if you don't pay the rent in full, but you do sign the declaration and return it to the landlord, then you do have to pay 25%. Now, logic would indicate that you have 15 days to sign that declaration and get it back to the landlord for this transition period. Logic would indicate that you would have to pay the 25% within that 15-day period. But that's logic. And this has nothing to do with logic. So the 25% is going to be due June 30th. And technically, if the tenant doesn't pay the 25% for those notices, those 15 days notices that you served for the period of, once again, September through June of 2021, then you can immediately bring forth an unlawful detainer come July 1st. Just give my office a call and we're happy to assist. Because unless they extend this, then as of June 30th, you're supposed to get that 25%. So if in fact, for example, the tenant owed $2,000 per month, maybe for the May and the June's rent, that would be a total of $4,000, and you served that 15-day notice, and the tenant returned the declaration, then the tenant would have to pay you $1,000 come June 30th. And by the way, he'd also have to pay the full rent come July 1st. The full rent come July 1st. So again, that's why I was telling the politicians there's this ticking time bomb of this 25%. And if you want to extend it through December of 2021, then the tenant literally is going to have to come up with, 16 months, at least 25% of 16 months rent. Guess what? They're not going to be able to do it. You know why? Because they bought that car like everybody else is telling me that their tenants bought. So for the transition period, again, we have to wait until June 30th. If you've already served your notice, then we can proceed forward. Now, assuming it is over come June 30th, what happens on July 1st for everybody out there? Well, on July 1st, they're going to have to pay you, number one, that 25% of the rent for that transition time period. Oh, by the way, I didn't tell you. I told you about the 25%. What happens to the 75%? Where'd that go? And that just fall off the mountaintop and roll down into the ravine? No. The 75% is also considered a civil debt. Okay, so you can never sue for that again, just like the protected time period. And that means you can go to small claims court on August 1 and sue for that as well. So that's the 75% that became due during this transition period. Okay, so let's move back to July 1st. What's happening then? Well, number one, your tenants finally have to pay a damn month's rent. Can you imagine? Can you imagine, ladies and gentlemen, that you leased out your property and you're actually, by decree of our wonderful legislators and our governor, that we can now get 1 month's rent? Well, that's wonderful. So on that date, let's pretend the next day, July 2nd, we would serve a 3-day notice to pay rent or quit, not with any of these other garbage forms, and we can immediately commence an eviction after the 3rd day. Okay? Again, we can immediately commence an eviction if they don't pay the 25% that was owed during that transition time period where you have already previously served a 15-day notice. Now, these laws have been written are incredibly difficult to understand, and in a lot of cases there's many conflicts within the law, and these things are all going to be decided, I guess, in a court of law. So some of the things I'm saying tonight are based on my interpretation of the statute, but not necessarily how a particular judge on a particular day will agree in court. But clearly, if the moratorium is over, come July 1st, the next day we can serve a 3-day notice for all the rent that's owed. Now, we heard Dan Fowler talking about the issue of the offering that they're going to pay 100% of the rent. Well, we don't know what they're going to do. My guess is that our governor just trying to curry favor with regard to the populace to prevent his recall, which, God be willing, he will be recalled. A little bit of my own political opinion there, like it or not. But currently there is a federal program where $2.6 billion giveaway by our federal government, which of course they have no money to spend, but they are giving it to the state of California. And the state of California has set up a program right now, the Tenant Rent Relief Program. And what this program does, and I encourage clients to at least attempt to apply for this program, because at least you'll get some money. The way the program works is that the landlord is supposed to apply for this program, and then an invitation is sent out to the tenant. If the tenant does apply, then the landlord is entitled to receive 80% of the rent, 80% of the rent, if the landlord is willing to give up 20%. So if you're willing to give up 20%, then technically you can get 80% of the rent. Now, my experience is telling me that very few tenants, when they've been invited to participate in this, very few tenants are doing so. Probably the reason is because they don't qualify, because they are working and they were just gaming the system and they don't want to sign these papers under the penalty of perjury that's going to go back to the state. So we're finding that very few people are actually taking advantage of it. And I'm also finding very few of my clients have actually received. I've only got a handful of clients who admit that they've gotten this money. To be eligible for this program, the tenant has to be within 80% of the local median income for that county. So he has to earn only up to 80% of what the median income is for that county in which it is, versus like Orange County, or LA County. And if they do, and if they are below that, then they can apply. But if they're not, then what we're talking about, this Tenant Rent Relief Act, is only for poor tenants. So if you've got tenants that have somewhat medium income or they're upper middle class or middle class, they don't comply with this. So therefore, you're not going to get any money on this, quote, Tenant Rent Relief Act. I don't know what any else is being proposed, but right now, so this program really is only for very, very low income tenants. And if your rents were, I don't know, $1,500, $1,800, $2,000, your tenants are not going to be able to apply for this. So when the politicians told us that they were not throwing our rent into the ocean, that this was merely rent deferment, let me tell you what they were doing, and it's really simple. They're lying. It's an absolute lie and fraud upon landlords. It's definitely a taking, and that's why if you can assist with the AOA PAC, AOAUSA.com/PAC, Political Action Committee, PAC, and please donate some money so that, not a lawsuit that I'm going to be handling, mind you, but a lawsuit that I am going to help finance. So if you can do that, that would be really wonderful, because what this is a taking, and it's against our Constitution. And quite frankly, as I said, it's asking one segment of society to support another segment of society. God knows the people in the world were affected both physically and financially by the pandemic. But there is no segment, no industry in the United States which was asked to finance another group of people, with the exception, of course, of income property owners. With the exception of income property owners. I do want to get a little bit local. Sorry for the people up north, but we get so many questions dealing with the local in Southern California. And I do have to caution that what I'm talking about is more for places that don't have their own local jurisdictional issues dealing with the eviction moratorium because of the pandemic. Los Angeles is insidious, the city of Los Angeles, in that they have an open-end statute. So this is just going to continue past July 1st. We think that they logically, based on the way the law is written, which says payments have to be commenced as of August 1st, 2021, we think that Los Angeles City will have to end their moratorium as of August 1st. We think, but there's no mandate for the city of Los Angeles. So for the landlords who are dying in the city of Los Angeles, waiting for this to be over, where you could finally serve a 3-day notice to pay rent or quit come July 1st, sorry to tell you that that's not true for the city of Los Angeles. For other areas in the county of Los Angeles, we believe that you will be able to, unless it's extended by the state, that you will be able to serve a notice to pay rent or quit, a standard 3-day notice, come July 2nd. You'll also be able to, in the county, it's a little bit crazy, you'll be able to, if you didn't get your rent from, not September, but the county, since they ended their September 30th. So for other areas in the county of Los Angeles, it's from October 1st, I know this is crazy, through June 30th. If you served a 15-day notice for that period of time, then you did it correctly. You didn't include September. And you're entitled to get your 25% come June 30th. You can start an eviction, God be willing, on July 1st. And then again, as of July 1st, you're entitled to make a demand for your July's rent and proceed forward like a normal tenant eviction case. So that's basically what's going on in the county of Los Angeles. Beverly Hills, believe it or not, like you need to have assistance in Beverly Hills, but Beverly Hills is similar to Los Angeles. They have an open-ended statute, so you're kind of stuck. The rest of the areas we can proceed forward with immediately with regard to July 1st, assuming the governor does the right thing. So I think that's going to, to apply for that housing assistance, if you can, for the rent relief, there's a website called housingiskey.com. Housing is key, So housingiskey.com. Go to that website and see if you can invite your tenant after you apply to see if you can get some of the money back. If you can, wonderful, do it. Because the chances, again, of you seeing a dime out of this money is probably slim to none. So I think, Jeff, we're going to open it up to questions. I'm ready to field any of your questions and try to take it easy on me because, it was a late night last night. So.
All right. Okay, so before we have questions, what we're going to do is we're going to give away one subscription to the AOA digital property management software. So if we could get the prize wheel up real quickly, and we're just going to do one, and then we'll go on to questions. And so this is just something we wanted to give away. It'll be for a year. Is it going? Okay. Anyway, so we're gonna. I think they're pulling that thing up. So while they're pulling it up, thank you, Dennis, so much for everything that you shared. That's from a fire hydrant right there, and there are a lot of questions, and we're going to get to them. And we'll do that prize wheel later. We can do that after all this is over. And yeah, so I will just go right to it. So Pete in the chat. Yeah, and so one thing here, if you tell us what city that you're in, and if you also tell us the specific time period that you're talking about, that'll really help us to answer the question specifically. What's that?
And the type of structure, like it's a house or an apartment?
Correct, yes, and the type of structure, whether it's an apartment, a single-family home, duplex, whatever it is. If you let us know full details, that's going to help us answer your questions better. All right, so here we go. Pete in the chat. Can a landlord evict with a 60-day notice for an exempt property in San Diego in order to sell the unit?
The answer is in San Diego, they put a moratorium. It's being challenged as we speak, but in San Diego, the Board of Supervisors stopped all evictions, period. I mean, unless it's dealing with health and safety. So that's being challenged. So any other county, I would have said, if your property is exempt, you can serve a 30 or a 60-day notice if the tenant's been there longer than 1 year. But this ordinance that the County Board of Supervisors for San Diego passed is insanity, and you can't do any evictions in San Diego. So time to just sell property if you're in San Diego.
All right. And in the chat, Victoria, thank you for your question here. How should we deal with unauthorized occupants in Los Angeles County, since we're not allowed to evict them, but we don't want them to become residents after the moratorium is over?
Well, certainly you don't want to accept rent from strangers. By accepting rent from strangers, you create a tenancy with them. So the moratorium talks about, this is for the city of Los Angeles, correct?
Correct.
All right.
Or county. I think it was county.
Well, if you have unauthorized occupants in your unit and that's a violation of the rental agreement, nothing prevents you from serving a notice to perform or quit and proceeding forward with an eviction if the tenant doesn't rid himself of those unwanted occupants from the unit. Now, in the city of Los Angeles, their statute says that you can't evict if it's COVID related to the breach of the contract. So in most instances, you can still go forward, and even in the city of Los Angeles, if there's unauthorized occupants in possession of the unit.
Okay, great. All right, Michelle. Guest house in the city of Los Angeles, tenant claimed COVID-19 and will not pay June rent. She won't qualify for the reimbursement because she makes too much money. Tenant plans to move out on July 1st. Can the landlord keep the security deposit owed for rent? Great question about security deposit.
Okay, so number one, you should thank your lucky stars that the tenant's moving out, because there's basically no way to evict in Los Angeles for non-payment of rent if they claim that it's COVID. Once she is out, then you certainly can deduct the security deposit from the amount of rent that's owed.
Great. All right. In the chat, the champ. Tenant has secretly installed a portable washer and dryer into my LA RSO 1950 building that wasn't set up for plumbing. My AOA lease says there are no modifications to the unit allowed. Since we're under this restrictive Los Angeles rent control, what are my options?
Again, I would serve in that situation a 3-day notice to perform or quit, to not only remove the washer and dryer, but to change all the plumbing back to what it was. The tenant will have 3 days to do so. That's a wonderful case for eviction that we can bring forth right now.
Great. All right. Renee Lynch in the chat. Can we use the April 21st CPI right now for rent increases in Los Angeles County, or do we have to wait until August 2021 to use the new CPI numbers?
And I did discuss this, and the answer is, assuming your property is subject to statewide rent control, you have to wait until August 1st to get the CPI as published for April of 2021. So the bottom line is, so that there's not much confusion, you're allowed a 5% increase plus the CPI. The CPI for April of 2021 is 3.6%. So you need to wait until August 1st, not too far away. And on August 1st, that day, serve your rent increase notice, a 30-day notice, raising the rent a total of 8.6%.
Great. And that's all except for LA City at this point, correct?
Well, if you're not subject to RSO for the city of Los Angeles, then, and you are subject to statewide rent control. Let's take, for example, a building built in 1986. A building built in 1986 is not subject to RSO, the Rent Stabilization Ordinance for the city of Los Angeles, but you are subject to statewide rent control. So on statewide rent control, again, it's 5% plus the CPI. You can serve that right on August 1st for a total of 8.6%. Now, if your property is subject to Los Angeles Rent Stabilization Ordinance, our wonderful mayor, Eric Garcetti, states that you can't do a rent increase for 1 year until he determines that the emergency period is over, and so far he hasn't. So it's 1 year after. So don't even think about a rent increase. I think Eric Garcetti thinks that you can get a rent increase when your grandchildren have grandchildren. That would be about it.
All right. Okay, are emails to and from the tenant considered adequate documentation when a tenant has been violating the lease? What are the best types of documentation that are supportive for owners in court?
Well, that would depend on what the violations the tenant is doing. For example, if he has a dog on the property, wasn't supposed to have a dog, then in that situation, you'd have to have proof that after the 3rd day, I don't care about the 1st and the 2nd, you're serving a 3-day notice to perform or quit. After the 3rd day, you would then have to determine that the dog was there. So maybe you go out in the morning, they're going to have to take the dog for a walk. Or I don't know about you, it's pretty simple to know if a tenant has a dog in the unit. All you got to do, knock on the door. You're going to hear a dog barking inside, so you would know. For extra people, for example, how do I prove that extra people are there? Do I have to have pictures? No, you don't need pictures. You just need to have 2 eyes. And that you see the same guy coming and going, or the same girl. You see maybe the guy using his key to get into the unit. You'll see the guy leaving in the morning. Maybe you know that he drives a yellow Camaro, so you'll see the yellow Camaro parked in somewhere on the block. And as we all know, wherever we are right now is where our cars are, because everybody who's listening to me right now, your car is right outside if you own one. So where you are is where your car is. So if you see the car, then you know the extra person is there. So it's not too difficult to establish that. Is it nice to have surveillance cameras that would take pictures of strangers? And the answer is, of course it would. But again, just your testimony is generally all that's required to say, yeah, I see the guy all the time. He's in the morning, in the evening, etc.
And also, just want to mention we did have a live stream on how to prepare for small claims court, and so that's a good one to go back to. And you can get to that by going to YouTube, and then just search AOA USA, and then it's going to show up down there. It was a couple weeks back, so that's going to be one that you can look at, and as you get ready for. As you prepare for small claims court.
You know, Jeff, on that note, I wanted to let everybody know, which I meant to explain, that my firm will be assisting. You can contact us in July, mid-July. We're going to be assisting landlords in preparing the small claims court paperwork, filing the paperwork with the small claims court, doing skip tracing to locate where your tenant is, unless you already know where your tenant is, and also giving information on how to go to small claims court, what you need to show, what documents you need to have with you. So we're going to do a little bit of a program, because we know that there's going to be thousands and thousands of landlords who are at least going to attempt to go forward with this. So someone should check with me at my office, and we're going to have this program with assisting landlords in filing small claims court actions.
Great, that sounds great. All right, Nancy on YouTube. Tenant approved for COVID-19 grant to pay missed rent in April 2020 through March 2021, but hasn't paid April, May, June in 2021. Can he be evicted, or do I need to take him to small claims court?
Well, again, for that period of time, we're talking about the transition period, so you would need to serve a 15-day notice to pay rent or quit. And if, in fact, the tenant didn't do anything, which is another type of an eviction that we can bring forth. You know, if your tenant you serve a 15-day notice and the tenant doesn't pay you a dime and doesn't return the declaration, that's a case we can bring forth right now. And quite frankly, we are bringing those cases right now where the tenant didn't return the declaration and didn't pay the full amount of rent. In addition to the cases that we bring dealing with unauthorized occupants or strangers that are now occupying your unit, or pets that they shouldn't have, or alterations to the unit, like the question was with regard to the installing of a washer and dryer. So those are all cases that we can bring forth. But with regard to your example, yes, serve the 15-day notice for that transition period. The tenant will have to pay 25% come June 30th, assuming you've already served it. And then the remaining 75% would then be part of a potential small claims court action as of August 1st, 2021.
All right, thank you. And Linda Abrams on YouTube. Who is litigating the constitutionality of California forcing landlords to work and continue to serve tenants for nothing?
There have been a few firms that are currently brought federal court lawsuits. There was an initial skirmish that I heard on one of the cases where they were trying to do a restraining order, which was denied by the federal trial court, but that's to be expected. It does need to move up to the appeals court for a better ruling. I'm predicting that these laws cannot be sustained, that they're not constitutional, and that we should have some success on the federal level.
All right. Yolanda Walker on YouTube. My tenant won't apply for the COVID grant. How do I still get paid for rent that he refuses to pay?
Well, of course your tenant's not applying because he doesn't qualify. Not only does he not qualify by being within that less than 80% medium income figure, but he's probably working and could definitely pay the rent. He's just using the system. That's my opinion. So what do? Just like what I told you, serve a 15-day notice. He's at least entitled to pay you 25% during the transition time period. And after that, you can sue for the balance in small claims court.
Great. And thank you. And in the chat, we have Crystal. Wasn't the LA County moratorium extended to September yesterday?
It was extended, but they have limited authority to extend it based on the state law. So we can bring forth, if the state law does not get extended, notwithstanding the wonderful actions of the moronic County Board of Supervisors for Los Angeles, we can bring forth an immediate eviction for the July's rent based on a 3-day notice. Okay, and I would love to challenge the authority of the LA County Board of Supervisors extending an ordinance that they knew that they didn't have the legal ability to do so. Now, they do have the legal ability to extend it for commercial rentals. They do have the legal ability to stop certain types of evictions, but certainly not with the rent one. We can go forward on July 1st, notwithstanding the fact that the County of Los Angeles has extended their moratorium.
Wow, making our heads spin here, right? It's just so confusing.
Me too. Trust me.
Lynette on YouTube. Tenant moved out and moved her sister plus 2 in without permission. Tenant says she still lives there and that the sister is only taking care of her father who doesn't live there. What can I do?
Now, what again would be a 3-day notice to perform or quit, giving them 3 days to get rid of the unauthorized strangers. At the end of the 3rd day, when the strangers are still there, you have the right to evict everyone from the unit. These are cases that we're bringing forth right now, and again, constitute, remember I told you that we've done 50 lockouts are occurring just in my firm alone with the sheriff's office for this week.
Mm-hmm. Now help me understand. I had a call in earlier from a Loretta, and how does that work? When do you give, so let's say you get a judgment for somebody. When do you serve the paper? When do you give those papers to the sheriff's office, and what does the timeline look like on that? How does all that work?
Once you get a judgment out of the court, you then need to get a writ of possession issued. Writ of possession is a court order ordering, in this case, the sheriff to perform a lockout. So generally speaking, we can get that in a couple of days, and then we would send it over to the sheriff's office for them to do the lockout. The process with the sheriff is once they receive the writ of possession and something called sheriff instructions, they will then process it. They will then eventually go out to the property and post a 5-day notice to vacate. And then at the end of the 5 days, the sheriff is not there. And because I know my clients see the notice to vacate and they say, well, the sheriff's going to be there on the 6th day. Well, no, the sheriff's not going to be there on the 6th day. The sheriff's going to be there based on their schedule sometime after the 5-day expires. So, and sometimes it can take a little bit longer. From when the sheriff gets the paperwork, we're usually quoting at least 2 weeks before the sheriff will actually schedule a lockout. When that lockout occurs, what happens is the law office, like mine, is given the date and the time of the lockout. In that situation, the landlord must be on the property, on the sidewalk in front of the property, with a person who's capable of changing the locks. Be there about 10 minutes early, because sometimes the sheriffs don't even stop. If they don't see anybody, they just keep rolling on by. And you certainly don't want to miss that lockout.
Wow.
That's a pretty big hassle. So in that situation, be there, and the sheriff will meet the property owner or the agent of the property owner and somebody who can change the locks. And what they'll do is they will allow the landlord or the locksmith to open up the door. If the tenant is inside, they will remove the tenant from the property to allow the landlord to change the locks. And then, of course, the sheriff has the sheriff moving van where all the sheriffs will get together and pick the tenant's furniture. No, I'm just kidding. The sheriff isn't going to touch their furniture. The tenant will be locked outside, and the tenant will have 15 days to retrieve their belongings. The belongings can be removed to any locked storage area. You don't have to keep it in the property, but you can if you want to. And then if, in fact, the belongings are worth less than $700, then the landlord can merely toss the stuff away at the end of the 15-day period. If the stuff is worth more than $700, then you actually have to hold a public auction, and you have to auction off the stuff.
Great, and I think you mentioned that in the in this June article of your June article in the AOA magazine. I believe you did talk about that a little bit. All right, Paul on YouTube. Thank you for your question here. Tenant owes April, May, and June. Well, we covered one just like, well, I'll read it anyway. Tenant owes April, May, and June 2021. Do they have to pay 25% of total 3 months rent or just 25% of 1 month rent before June 30th, 2021?
They would have to pay 25%, assuming the 15-day notice was served and assuming the tenant returned the declaration. Then, assuming you've already done that and the notice has expired or will expire by June 30th, the tenant will have to pay 25% by June 30th. If the tenant doesn't, then you have the right to immediately bring forth an eviction lawsuit at that point in time.
Right, and for all 3 months at once, correct?
That's correct. In the notice, you would have already put in the April, May, and June's rent.
Right, I think that was his main thing. Is it 1 month or is it all months? Because
well, you can do it separately, but if you haven't served one, then include them all.
Yeah. Okay, great. On YouTube, Deborah, I have already sent numerous emails to Governor Newsom, Mayor of Redondo Beach, LA County Board of Supervisor, Assemblymen, and state senators with no response. Not a question there, but Deborah, congratulations, you're doing the right thing. And what needs to happen is everybody needs to get involved. And Deborah, you are not alone. I've done it. I know a lot of people that have done it, but we need more and more people to do it. And I think we have to persist and we can't give up. And so let's just stick it out until we reach our goal. And
well, Jeff, on that note, when Eric Garcetti, the mayor of Los Angeles, first came into office, he said that for businesses in the city of Los Angeles that he was going to end the gross receipts tax. That's where whatever receipts come in to any business, including apartment house owners, you have to pay a percentage, like 1.25% of the gross receipts coming in. Eric Garcetti, as part of his campaign promise, agreed that he was going to end the gross receipts tax. And I can tell you, ladies and gentlemen, that still exists, and that landlords have to pay it and businessmen have to pay it. And they tend to go after businesses such as my law office, and I have a friend with Meat Distributing Place in downtown Los Angeles, and also one who is involved in acquisitions for real estate, and they seem to all go after it. So I made a stance when I knew that Eric Garcetti wasn't going to listen to my pleas, that he should at least live up to his campaign promises. And I made a decision that I was going to move. And move I have done. So our offices are now moving about, 7 minutes to the east. And we're going to go to a beautiful city called Burbank. And that's where my new law offices will be. And Eric Garcetti, I want to tell you personally, I am so happy not to be paying you any gross receipts tax any further. And maybe when you go to India, you can possibly think about me.
Oh, boy. All right, here we go. Wendy S., can we raise the rent in Ventura even if they aren't paying? Wendy S.
And the answer is, if your property is not subject to any rent control, you can raise it unlimitedly. If your property is subject to statewide rent control, again, wait till August 1st, and you can raise the rent to 8.6% if you serve the notice on August 1st. Why should you do that? Since, hey, the tenant's not paying me anyway. Why should I raise the rent? Well, you should raise the rent. You should raise the rent because the tenant will ultimately always owe this to you, whether you can find him or not. And I think it puts a little more onerous on the part of your tenant. So definitely raise rents to market value. You cannot raise them higher than market value because no one will rent from you. But you certainly can raise rents to market value.
Great. Okay, on YouTube we have Robin. All my commercial tenants applied for SB loans and were approved, and not they all got a letter that they can no longer give them the loan due to a lawsuit. I am owed over $3.5 million in rent. I'm
not sure what the SBA loan has to do with the payment of the rent unless they were expecting the loan to pay their rent. But again, not
Yeah.
sure. It's unfortunate, obviously, with regard to the fact that the landlord's not going to get their rent. But whether they get a loan or not, the landlord still has options to bring forth a lawsuit.
Right. And you mentioned something about commercial for the city of LA.
The city of LA, if you're a commercial landlord, I'll give you 2 words that will typify your situation. The 2 words, I'm sorry. There's nothing you can do. There's no protection out there for you. The tenants can just claim COVID until the day they die or until the day the mayor dies in the city of Los Angeles. If you're not in the city of Los Angeles, you come under the county of Los Angeles rules. And very few people know that you can actually start evictions for non-payment of rent in the county unless, and don't tell any of your tenants this, unless the tenant in writing or if they have more than 9 employees, they would have to give you a letter in writing every single month within 7 days of the due date telling you that they had an inability to pay because of COVID. If they do that, then you cannot start the eviction case. But if they don't send you a letter within 7 days of each due date, then we can serve a 3-day notice to pay rent or quit and start doing evictions based on commercial establishments, and we've been doing that. Now, if they have less than 9 employees, then they do have to tell you each month. They don't have to put it in writing. I don't know why these laws are what they are, but they do have to tell you each month within 7 days of the due date. So if your tenant, you have a commercial tenant, and he's been pretty silent with you with regard to the reasons why he hasn't paid the rent, again, we can serve him with a 3-day notice and proceed forward with a standard eviction in LA County. But again, City of Los Angeles, forget it.
Alrighty. Okay. Next one. Starting over. Application with tenant submitted to Alameda County for the 80/20 program versus the state. No word back, and the tenant has not paid rent since February 2020. When can I start to evict?
So February 2020, he hasn't paid rent. So ladies and gentlemen, that landlord has not received any income for 18 months. 18 months. Who could live without receiving income? Oh, and by the way, during that 18 months for that poor landlord, did he have to pay his mortgage payment? Did he have to pay his property taxes? Did he have to pay the utilities for the building, like water and sewage? And also, in that same 18-month period, that same landlord, if confronted by the tenant telling the landlord that, hey, my garbage disposal doesn't work, my air conditioner went out, does the landlord have to comply by fixing that? And the answer is yes. There's absolutely no relief. For that particular landlord, I would advise serving the 2 notices, the 2 15-day notices, one for the transition period and one for the protected time period. At least for the transition time period, 25%, at least at the end of the 15-day period, or on June 30th, whichever is later. And then come August 1st, you'll be able to sue for 75% of the rent for the transition period and all the rent from, in this case, February through August 31st in small claims court.
And that is Alameda County. Should they check with local up there maybe?
Yes, you probably do want to check to see if they have their own eviction moratorium rules, which are different than the state rule. Good point, Jeff.
You could check with Richard Beckman. He's up there, and just look in the AOA magazine. If you're not getting the magazine because you're not a member, you still can go on AOAUSA.com. You can look up your edition in your location and just look at the list of eviction attorneys that are up there, and you can consult with them. We do have an office in Alameda. Allison's awesome, so shout out to her, and she may be able to point you in the right direction as well. And here we go. Lexi Rose. Is the program where landlords can get 100% of the unpaid rent for commercial landlords or residential only?
residential only. There is no assistance for commercial landlords, even though, by the way, you know, the Tenant Relief Act doesn't apply to commercial at all.
Right.
So it's only if you have a local jurisdiction which is preventing you from doing evictions for commercial establishments. So in most counties, for example, like in most of Orange County, Riverside County, in San Bernardino, Ventura, these are cases that are wide open. If you got a commercial tenant not paying, you can serve a 3-day notice and then hopefully call my number, and we'll be happy to initiate that case for you.
Great. All right, Courtney Jade on YouTube. Fourplex, Whittier. Tenant has recently moved in an additional 2 adults plus children. We kind of asked this one before. Oh, it's a little different. 2 adults, 2 children into the unit without my permission. We know what the answer is to that already, since you shared it already. Am I able to increase the rent, and by how much, or provide them a 3-day notice to quit?
That's an interesting question. Your property, since it's multiple units in Whittier, and I presume older than 15 years, so your property is subject to statewide rent control. Are you allowed to raise the rent for extra people moving in? And that's a question that hasn't been decided. We know that if you wait till August 1st, you're going to get an 8.6% rent increase. But what if unless your rental agreement if your rental agreement's silent, then there's nothing that you can do to raise rent. You could ask the tenants to leave and commence an eviction. But what if your rental agreement says, hey, if you bring in an extra person, as the AOA rental agreement states, and you must pay an additional $100. So that really hasn't been decided under the statewide rent control issue, AB 1482. Can you charge additional rent in excess of the statewide rent control when your rental agreement specifically stated, hey, I can get an extra $100? My guess would be that you probably could raise the rent, but it certainly hasn't been tested. And easily I could see judges going south on that issue.
All right, thank you. And then Courtney on YouTube, thank you for your question. If the guest stays for over 14 days, like at what point does a guest become a tenant and where you would be able to serve?
Well, I know the AOA rental agreement specifically says guests staying over 14 days lose their, quote, guest status and now become occupants of the unit. So if that's what your rental agreement states, I think you can go with that. Another rule of thumb, if your rental agreement is silent, I would say 30 days, that if the person, you can have your grandma come from, Duluth and visit with you. But if, in fact, they're there longer than 30 days, I think they lose their, quote, guest status and now are occupying your property in violation of the rental agreement.
All right. Valerie. Moratorium through September is for all California counties or just LA County? We answered that. We can keep going, I think. Okay, my friendly agent on YouTube. It's crucial to speak up right now. Is writing a letter the best action to take? How about a social media movement? Too many of my clients have had their hands forced. They feel forced to sell.
And I feel the pain with that. I think a letter campaign is good. Unfortunately, there are a lot more tenants than there are income property owners. And I think really, while a letter campaign is good to at least put this in the forefront for the politicians, someone was telling me that when the county extended it, there was a blog, and everybody on the blog was saying, hey, enough is enough. California's open right now. I'm not wearing a mask, you see? And I have been vaccinated. So California's open, and tenants are going back to work if they want to go back to work. So it shouldn't have been extended. And even the groundswell of comments were so in favor of the landlords and for the county not extending this. But the truth of the matter is the politicians are going to do what they want. And that's why I think we have to hit them with lawsuits.
Yeah.
I think like the political action campaign that you guys are starting, which will fund these lawsuits, which are so necessary to move forward with and to protect our constitutional rights. You know, our country was founded upon property rights. That's why the Pilgrims came here. And we see an erosion of property rights like I've never seen before.
Right, and I would say to that, go social media, let's do everything. It's kind of like when there's two desserts out, go for both of them, right? So in this case, send them the snail mail, send out the email, go on social media, do everything. And we just have to do all that we can. What else can we do, right? And then, yeah, it's going to take donating and having a fund build up so that whatever good lawsuit, if there's a good one that's written that's gaining traction, then we can put money towards that and help out with that. And so that's what we're wanting to do. And I know it's frustrating, really frustrating, and for all of us, you know. And I mean, I lived in a place for 11 years where the government ran most of the housing, and I'll tell you, there wasn't. It smelled like mold. Most of the properties had leaky roofs, and there wasn't enough housing. And what we're getting to right now, when they want to house homeless people that are unhoused, when they want to do that, there may be a great motive to it. But where do you think what's that gonna lead to? When you go to Venice Beach and you build 200 units at 10 times the price of what it costs because you're doing it as the government, when you go build 200 units, who do you think's gonna show up there? You're gonna get another 400 people that are unhoused right in that area, in addition to the 200 that you just housed. If you build it, they'll come, and they'll come more and more and more. So our answer is it's not gonna be just building and giving things away more and more. It's not the handout that's going to help. It's going to be the hand up, and all these things. It's failed policies. We all see it. All right. My tenant applied for the COVID-19 rent relief about 2.5 months ago. She owes over $5,000. Has anyone received the rent relief payment? And you did say that you had a few. And our last live stream that we did a few weeks back, there were people that have received it. But what I read, I think it's 2%, something like that. Dennis, you have any other numbers about the number?
No, it's a very small percentage of people. Either the tenants just don't care, and why wouldn't you care? You know, if you're a tenant and you apply, okay, which takes basically nothing to do, you're going to get free rent from April 1st, 2020 through March 31st, 2021. 1 year free rent. Why wouldn't you do that if your landlord invited? And the simple issue is because you either can't get it together, that's just what your lifestyle is, or you know that you don't qualify and you don't want to commit perjury by filling out these papers, and you knew that your actions were just to game the system. Once again, if you're going to have laws that are passed which allow people to steal from other people, then guess what? Then people are going to steal from other people. This needs to end now. Mm-hmm. Give landlords a break. Allow us to do our business. Or just sit there and give money to tenants outright. But do not put this financial burden on the backs of landlords.
All right, let's see, YouTube. For statewide rent increases, can we serve notice now at the 8.6%? You did answer that. For the rent increase to become effective, oh, here we go, a little nuance. For the rent increase to become effective 8/1/2021, or do we need to wait until August 1st before we serve that?
I think you have to serve it on August 1st.
Okay.
That's my understanding of the law. And again, it's really poorly drafted, but my understanding is I would wait till August 1st, serve it on August 1st, so to take effect as of September 1.
All right. Black Box LA. I keep being told that in LA County, breach of lease won't go through. For example, illegal pet like a pit bull, inoperable vehicles, and 30-day termination and didn't vacate. He keeps being told that. What do you say, Dennis?
You can evict for those reasons. I don't know about the last one, which is failure to vacate. You can't just, if it's under statewide rent control, you'd need to have a reason to evict. But you can evict for those reasons in LA County.
Great. And, you know, I had one. There are, you know, like if you look at LA City, there was a 30-day window where people could apply. Beverly Hills had the same type of thing. Those things are completely closed, and there's no way for people to apply for rent relief in those two areas. Is that correct, or should they try another means? What would you suggest?
I would just go with the state one. The other ones are closed. They had a short window.
Yeah.
I mean, they had a limited amount of money, so you know they kind of hid the ball, so to speak. And then, of course, the time period ran out. So very few people really got anything on that. This is just a theft of services from landlords and income property owners. It's just an out and out theft. And anybody out there who doesn't believe what I'm saying, then I don't know what industry you're in, but why don't you just take all the money that you earn and just start giving it to random tenants and see how you feel? Because that's basically what we're looking at here.
All right. So on YouTube, Grace, under City RSO, can we evict if tenant has a dog and complex has no pet policy?
If you have a specific rental agreement which prohibits pets and they bring a pet in, the answer is yes. We can do that eviction, and we are doing that eviction, and we're getting people locked out based on that reason.
Right. So you need a written agreement. You need that in the lease already, and correct?
That is, yeah, you must have a written rental agreement signed by the tenant which specifically talks about that provision.
All right. This is maybe you understand what they're talking about here, but Sylvia, how can I get this information from Dennis in writing? So maybe, I don't know which information it is, but how can they get information from you?
Well, of course they can call the office. This video is going to be replayed, so you can always go to the AOA USA website. I'll also put it up on my website, which is evict123.com. Have it transcribed. But otherwise, if you do have a specific question, at least for our office, you can always call our office. And also, of course, the Apartment Owners Association also gives information regarding these topics.
Right, and that evict123.com, it's on the screen below there, Dennis, so people can see that. In the AOA USA also, we have some COVID forms. There's that information. And yeah, just give Dennis a call.
By the way, my number is 1-800-77-EVICT if you don't want to use the numbers there. 1-800-77-EVICT.
All right, how much more can you endure here?
We can do a couple more.
Okay. We have a bunch, but that'll be great. Let's see, who do we have? Joel Horowitz, multi-unit property in the city of San Fernando, not under statewide rent control because cert of occupancy is less than 15 years.
Okay, what's the question?
Can I evict is probably the question.
Okay, so the answer to that is simple. If you're not under statewide rent control, then you don't have to have a reason to evict. So if the tenant is on a month-to-month tenancy, then you have the right to serve a notice to quit. If the tenant's been there longer than 1 year, it would be a 60-day notice. If it's less than 1 year, or 1 year or less, then it's a 30-day notice. So you don't have to have a reason. You get the forms from, of course, the Apartment Owners Association, and serve that. By the way, make sure if your property is not under rent control, like I told you, you've got to serve, we serve it with the notice to quit, but do it now, that a notice to your tenant that your property is exempt from statewide rent control. You must do this. Otherwise, what's happening when we've seen this already is that you serve a 60-day notice, my property's not under rent control, Dennis told me I could do that, and I did. Then you get to court, and some smart attorney on the other side is going to say, did you inform in writing your tenant that your property was not subject to rent control? Did you serve them a notice? And if you answer no to that, then that means your case is lost. So please, right now, if your property is not subject to rent control, serve that notice right now. If you're renting to a new tenant in the rental agreement, it's got to state that your property is not subject to rent control. Conversely, if your property is subject to statewide rent control, you need to serve your tenant with a notice informing him that it is. And also, if you're leasing out apartment, then that notice has to be contained inside the rental agreement.
Great. Here's Suntech Incorporation. Can we not renew the lease for a LA City non-RSO apartment?
Well, in my opinion, you cannot renew the lease. The question is, can you evict? And we've had mixed results on that. The city of Los Angeles states that there is no such thing as a no-fault eviction. So therefore, if you're on a month-to-month tenancy and you're not subject to rent control, any rent control, you still cannot, in the city of Los Angeles with our wonderful mayor, you cannot just serve a notice to quit, because that would be considered a no-fault eviction. Now, the question is, what if I have a lease and the lease expires as of June 30th? And in that lease, it says, you got to get out. I mean, that's basically what it says, that the lease was from July 1st, 2020 through June 30th, 2021. And it states that there can be no holdover. Now, your property is not subject to rent control. So we brought a number of those cases to court. And we were successful, I would say, in about 65% of them. In about 35% of them, the judge determined that that was considered a no-fault eviction, even though our position was, well, hey, he had to get out. It's his fault that he didn't get out, but a lot of judges didn't. Certainly the judges in the local area where we are right now in Van Nuys weren't big supporters of that. So we've tried to back off of those types of evictions.
Okay. All right. Okay. Facebook. Yeah, I hadn't seen anything from Facebook. Here we go. If an owner, this is from Amelia. Thank you for your question. If an owner has not given any notice for the entire COVID-19 season, what is the first step they should take?
You're saying that the owner hasn't given any notice?
Yeah, if the owner hasn't given any notices.
Okay, well, there was a notice that needed to be served. I think it was August 31st. That was the information dealing with AB 3088, the Tenant Relief Act. If you haven't served that notice, I would serve that notice right now. If your property is not subject to any rent control or subject to statewide rent control, then you should also be serving those other notices that I've already talked about.
Great. It is 2:43.
Let's do two more, young sir.
Okay, here we are. Amelia, if a tenant in lease has allowed the other people to... Okay, we kind of have done that. Astro, Lizard TV. Can I serve a 60-day notice to vacate in Long Beach, LA County, if I am selling the property?
Well, it depends. If it's a single-family home, then, of course, you're not subject to any rent control. If Long Beach is tied to the statewide rent control, so you'd have to have a reason. And I can tell you categorically that a reason is not, I'm selling my home and I want this person to move. That is not a proper reason if you're subject to statewide rent control. So you're going to have to allow the new owner to terminate the tenancy, maybe based on that catch-all way of evicting people based on renovation.
Okay. And, we're going to take one question, but did you know that we have over 100 questions that we haven't been able to answer? And
wow.
Yeah, so this has been very well attended, and you can review this again. But also, Dennis, I think you're coming in August as well. I think you'll be speaking in August. I think it's August 14th. So just check the calendar, and you can catch back up. But you can call. I think you probably need your questions answered now.
Now you promised for the August meeting, Jeff, correct me if I'm wrong, that you were going to have a limo pick me up and you were going to cater lunch. Is that correct?
Oh, putting the pressure on. Here we go. Yeah, catered lunch. El Pollo Loco is right there.
Perfect.
It's fine cuisine.
I don't mind crazy chicken.
You like it or you don't?
I actually do like it.
I do too, and I like anyway. So
We're giving a plug here. I don't know why.
Yeah, well, they're good next door neighbors, so there they go. All right, okay, Grace Kim. A few days ago, I heard LA City just extended to 9/30/21 for evictions. Is that true? That's a yes.
That's actually no, it's not true because LA City
right.
doesn't have a time period. They have an open-ended emergency state. And again, the county did extend it to September 30th, but they don't have the right to extend it in regard to non-payment of rent cases. So for non-payment of rent cases, if our pesky little governor doesn't extend this, then get ready to cinch up the saddle and jump onto the horse because on July 2nd, we can start serving 3-day notices to pay rent or quit.
All right. Well, everyone, thank you so much. I did promise that we'd give away one of those AOA digital subscriptions for a year. And so this is property management software. And if you're an AOA member, it connects to your account. It has the AOA forms in there so that you can send those and connect to your AOA tenant screening account. So when you get that rental application, you can send on that information without having to worry about human error. And anyway, we're going to spin the wheel if I can get it going. Let's see. Okay, here's the wheel. We're going to spin it. Let's see who wins. Yeah. This will be quick.
Closing statement.
Okay. Okay. There it is. Michael Britch, it looks like. You are the winner. So congratulations to that. And we're going to have Dennis Block give parting words and wrap this thing up. Next week, or July 15th, we'll see you with Carla Dennis. You're going to want to learn. You're going to want to see that. She's dynamic and fun. And she'll help you. She'll give you some ideas on how you can keep more money in your pocket instead of giving it to Uncle Sam. All right, Dennis, last words, parting words for us.
Last words. Well, number one, I want to thank everybody for listening to this. And again, you can go to the AOA USA website or my website, evict123.com, and you'll catch this broadcast again if you missed anything of it. We have an office number, 1-800-77-EVICT, if you appreciate the opportunity. Again, the AOA USA is really the best apartment association in the state of California. And I really encourage everybody listening to me, if you're not a member, the price is ridiculously low. Join and come on board, and let's all work together to see if we can knock these evil politicians off their horses.
Great. Well, thank you so much, Dennis. And we'll sorry that we couldn't answer all of your questions. And we hope to see you on the 15th.